can also publish materials about the previous day events during the next day. And after our last panel, it will be the last panel, but not the last event of our evening. After this discussion, we will see a small but very interesting presentation. It should be probably really short, but I think it was to wait. So, the last panel of the first day of our summit, it's Prosecuting International Crimes, Lessons and Legacies of the International Hybrid and National Mechanisms and or Tribunals. And panelists are Ambassador Clement Williamson, Georgetown University Center of National Security; Mark Ellis, International Bar Association Executive Director; Jeremy McBride, Barrister, Moncton Chambers, London, member of Council of Europe Expert Advisory Group to the Office of the Prosecutor General of Ukraine; Davorka Kolak, Deputy Country Prosecutor in Zagreb; and Andrew Kearney, Senior Advisor in the Prosecution of International Crimes, European Union Advisory Mission, Ukraine. And moderator is Mykola Gnatowski, Judge of the European Court of Human Rights. So, if we are technically ready, let's check microphones. It will be useful. And one more time, I want to remind you that after this panel, we will have a short but very interesting presentation. Yes? No, it doesn't work. So we are ready to start.
Okay, good evening, ladies and gentlemen, Your Excellencies, Mr. President. This is the last panel of the day, not the last event though. We'll try to make it a panel that will not immediately set you sort of ready to go to sleep, but rather ready for the very interesting presentation that we are all, been warned about. I'm really delighted to be here, and I'm very grateful to the Prosecutor General Kostin for his kind invitation, and also honored to moderate this session. Unfortunately, my current job does not allow me to say much in terms of substance, but at least I'm allowed to moderate, which is already excellent news for me, as all these questions are extremely dear to me. We have listened today to the political leaders, to the bosses, so to say. We, I think, have been already able to ascertain that there is resolve, that there is political will. And there's also different avenues for reaching the goal, so to say. But the political choices must be well informed, and they must be well informed, including through the work of and through the experience of people who have the hands-on experience of these issues. And here is the panel, which comprises 5 excellent professionals, persons who have directly dealt with internationalized and also domestic war crime trials. So without any further ado, we'll start this panel, and I will ask a question to each of the panelists, which would, in my opinion, broadly correspond to their experience. Start with Ambassador Clement Williamson, who is not only, as he was already introduced, the Senior Director for the International Justice of the Center of National Security at Georgetown University, but he's also formerly the US Ambassador at Large on war crimes issues. The experience is indeed enormous, and this is the experience which directly deals with international criminal justice, with international justice in principle. And my question to you, Ambassador, do you think that international criminal justice is adapted to today's realities? And if not, what should be done to adapt it?
Thank you, and thanks to all of you who have stuck with us to the bitter end today. So I will try to be brief. I think we need to recognize that international justice has changed significantly over the last 25 years. I started work at the International Criminal Tribunal for Yugoslavia shortly after it was created in 1994. And this was really the high point of international justice. This was the period after the collapse of the Soviet Union. Even Russia and China were being somewhat supportive of international justice. They at least adopted a fairly pragmatic approach to it. Over time, we saw that change. We saw that it became much more difficult to get a consensus in the UN Security Council in particular for justice measures. As we all know, when Vladimir Putin became president of Russia again in 2012, Russia's hostility became even more pronounced. And since that time, Russia has done everything it can to thwart accountability efforts in places like Syria, in Myanmar, and it's an approach that China has largely adopted as well. So the political reality today is that securing a consensus for international justice has become incredibly difficult. And we've had to look at alternative approaches. Beyond the political constraints, we also have to start with the recognition that even where we've had standalone international tribunals, like the ICTY and ICTR, they've had limited reach. The ICTY conducted about 160 prosecutions in all. The ICTR, it was around 90 prosecutions, close to 100. These may sound like large numbers, but when you look at the thousands of other perpetrators that were identified for crimes in Yugoslavia, in Rwanda, that fell to the domestic systems, you recognize that it really only did have a limited impact. And this is a scenario that is undoubtedly going to be replicated in Ukraine, where we have tens of thousands of cases that need to be addressed. So we have pursued in Ukraine a multifaceted approach to justice. It starts with the recognition that we do have a viable international mechanism here through the International Criminal Court. And we need to be very supportive of the ICC's efforts here. While it's still in a formative stage, we have seen concrete steps being made toward the creation of a standalone international court to deal with the crime of aggression. And this would certainly supplement international capacities. But either way, the vast majority of cases are going to have to be handled through the domestic system and by the Office of the Prosecutor General. And we have to find ways to support them over the long term. The initiative that I'm leading, and another role that I have, is as the lead coordinator of the Atrocity Crimes Advisory Group, which is a joint undertaking by the European Union, the United Kingdom, and the United States, implemented by a consortium of non-governmental actors to support the Office of the Prosecutor General. My successor as Ambassador for Global Criminal Justice, Beth Von Scott, mentioned this in her comments earlier. But this is a process that started actually 1 year ago today, when I first arrived in Przemysl, Poland on the border, started meetings with the OPG 1 week after the conflict started with a group of prosecutors and other experts. And this is a process we have continued since that time over the last year. But it's the example of the kind of innovative approaches that we're going to need to take to deliver justice as it becomes more difficult to rely on the models that we've used over the past 25 years. And Ukraine really presents an opportunity for us to create something new that combines models that are achievable for delivering justice despite these political challenges. So just very briefly, in practical terms going forward, what do we need to do? I think we have to start with a prosecutorial approach, with a strategic prosecutorial approach that has a clear understanding of the division of responsibilities between the various actors. We have to recognize the limitations of what international courts can do, what the ICC can do, what even a standalone tribunal is going to be able to accomplish. And once that's done, we need to use those limited resources as effectively as possible, targeting the senior-most political and military officials. And then we need to strengthen domestic capabilities to handle the rest. And we need to recognize that these accountability processes in the domestic system are going to go on for many years. 30 years after the conflicts in the former Yugoslavia, Croatia and Bosnia are still dealing with huge numbers of cases. It's critical, therefore, that all of us here commit to long-term support for the Office of the Prosecutor General, for other Ukrainian justice and law enforcement institutions, because this is what is going to be necessary to deliver justice. And to just recognize this is going to be a marathon, not a sprint.
Thank you so much. Thank you so much, Ambassador, for these remarks. And I think this lays an excellent foundation to our discussion today. And let me turn now to Dr. Mark Ellis, the Executive Director of the International Bar Association. You've been personally involved in the work of international and domestic tribunals. So what would be the main lessons that your experience would suggest for Ukraine to achieve the goal of ensuring accountability? Dr. Ellis.
Thank you very much. It's great to be here. This is my second visit to Ukraine since the war, and it's always inspiring for me to be here with my Ukrainian colleagues. What I thought I would do is just mention quickly what I think are this is about lessons and legacies. I'm going to mention 5 lessons based on my own experience with these various tribunals. But I start with what Clint said at the beginning, which we really have to reiterate. I have to reiterate on this. It's a mosaic of accountability mechanisms, but it's the domestic mechanism that is going to be front and center of accountability for Ukraine. And so for me, I thought, well, I'll just touch on some of the lessons that I think are going to be relevant for the domestic prosecutions here. The first, we talk about political willingness, international pressure. That's generally relevant to international courts. They've all struggled with those issues of gaining support for their decisions, their arrests. And of course, we spoke this afternoon or this evening about the political willingness behind the creation of a special court for a special tribunal for aggression. But the political willingness to support Ukraine in its domestic prosecutions it will be front and center. And it touches on supporting investigations that we've talked about and supporting arrest warrants that will come out. All of it is there. And again, something that Clint said that I thought, well, we're both on the same page on this. It's essential for the international community to assist Ukraine, not just this year, not next year, but years from now, as Clint had mentioned, because international justice plays the long game. That's just part of the pluses and minuses to it. So we have to be prepared to do that. I have no doubt, based on everything that I've seen over my visits here and meetings, that the international community will be there for Ukraine in this very important area of domestic prosecution. Second, judicial competence. The process to which the judges are trained and vetted to undertake these war crimes trials and to inspire public confidence is really quite important. These are complex trials, and we know that we do not have a special domestic court for these war crimes trials. There will be judges who will, among the regions, undertake these cases. And so the training judges, you heard Howard talk about his involvement with that, and I know there are a number of actors focused on this. I've had meetings with the Judicial Training Center, which many of you are familiar with, and I'm very impressed with what their plan is and what their initiative, including something really innovative, and that's creating a core group of international judges who will be kind of mentors to the domestic judges on these very, again, complex areas, and the IBA will be providing support on that. Third is executive interference. And although I don't expect this to be an issue in Ukraine, I assure you executive interference has been an issue in many, many courts, particularly domestic courts, whether it's in hybrid courts, whether it's Cambodia, the Iraq tribunal. And it's just something to keep in mind. It's easy to all of a sudden you move into a situation where the executive begins to have some positions, some opinions on the court process, and that's dangerous as well. Fourth is the special challenges to domestic tribunals. I've already said undertaking atrocity crimes in the best of times is exceedingly difficult. Ukraine's doing it in the midst of a war, and that can be nearly impossible. But again, I've been extremely impressed with the effort here. But the international community has to provide training, but not just to the judges. It has to include defense attorneys. And I recognize that this is really complicated and difficult and very emotional in any war situation to say, in order to ensure that Ukraine adheres to international principles of justice, impartiality, providing competent defense is absolutely essential. And that's something that, again, I've seen here with the Coordination Center for Legal Aid, and we're providing assistance directly to them. And I'm very optimistic that this will not be lost in Ukraine. And even the Prosecutor Kostin, has been very upfront to say we have to have this type of support. Finally, I really encourage that there is a media outreach process here for these domestic tribunals. Having an effective media outreach in order to really inform the public, domestic and international, really is crucial. And what it does is impedes kind of the constant speculation, misinformation about what's happening in these types of trials. And so I've seen where domestic tribunals have lost their way because they simply don't provide this type of information. It's a relatively simple thing to do, but absolutely crucial to do. And my last point is the perception of fairness. I returned to the first time I went to the former Yugoslavia and met with Justice Richard Coldstone on the Tadic case. And I was there for about an hour. I was there to hopefully to provide assistance to his office. But in the end, he said, I need your assistance in providing help to the defense. Why? And this is what he says of a prosecutor. The yardstick measurement of this first case, the Tadic case, will not be whether Mr. Tadic is convicted, but whether he's to have been perceived to have had a fair trial. And that was the prosecutor doing that. So it comes back to this issue for me as Ukraine's legacy. This will be part of Ukraine's legacy. Undertaking these domestic war crimes cases consistent with international standards of fairness and impartiality. This is critical. This is not happening in Russia, that we know, but it's Ukraine's legacy to make sure it will happen here. Thank you.
Thank you so much. Thank you so much, Dr. These precious elements. And let me turn now to Mr. Andrew Carney, who is the Senior Advisor in Prosecution of International Crimes at the European Union Advisory Mission in Ukraine. The European Union has its own unique experience with dealing with international crimes and also internationalized issues of internationalized criminal justice. The European Union has its unique experience in the Kosovo specialist chambers, and in fact, quite often when there was a discussion about the European Union assisting Ukraine somehow in working with international crimes, and even when it came to the question of prosecuting the crime of aggression, this Kosovo model was being mentioned. So my question to you is, do you think this is a model which can prove useful in the Ukrainian case? And if so, in what way? Thank you.
Sorry, is that working? Yes, it is. Thank you very much indeed, and thank you for the question. I should say that what I will say now is not necessarily meant as an endorsement of the Kosovo models as a way forward for Ukraine, but rather as a part of the evaluation of previous and current tribunals and internationalized courts to see whether in fact there are elements of certainly the Kosovo model from the past which can be applied to Ukraine going forward. So what I'll talk about are two of the Kosovo internationalized courts that were established following the conflict back in 1998 and 1999. And again, that's a way of informing the possible future for a Ukrainian court, if there are lessons to be drawn, or in fact not, if there's really sort of no relevance. But I should say my observations are based upon, firstly, working as a prosecutor of war crimes and organized crime within the Special Prosecutor's Office in Pristina as part of the European Union mission called EULEX. And secondly, some years later, as a prosecutor at the Specialist Prosecutor's Office of the Kosovo Specialist Chambers in The Hague. And at the Specialist Prosecutor's Office, we in fact investigated and indicted what became the first war crimes trial before the Chambers. That was the prosecutor versus or against Salih Mustafa, a senior Kosovo Liberation Army commander, and in fact he was convicted very recently in December of this year and sentenced for war crimes including torture, murder and cruel treatment of what happened at a detention location. The trial of the largest case, which indicts the former president of Kosovo and in fact 3 other former senior commanders for crimes of humanity and war crimes, in fact will start next month. So this is the Kosovo Specialist Chambers is a very active court at the moment, so worth paying attention to. There has been mention of the Kosovo model, but in fact Kosovo has experienced a number of models over the years. It's somewhat unusual in that it's had a tribunal, if I can say, presence for almost 30 years, starting with the International Criminal Tribunal for the former Yugoslavia, the ICTY mandate, then joined by the United Nations Interim Administration, so UNMIC, then EULEX, and since 2015, in fact, the Kosovo Specialist Chambers. And indeed, following the cessation of hostilities in 1999, UNMIC was mandated to exercise executive authority within Kosovo. And in 2009, in fact, a number of those UNMIC executive functions were taken over by EULEX, and the UNMIC international judicial panels were replaced by the assignment of EULEX judges and prosecutors operating within the national system, so effectively an ad hoc hybrid court system. Now, I do have just a number of non-exhaustive observations from the operational level regarding this hybrid court system. And I will say in praise of it was that international prosecutors and judges were truly embedded with national counterparts and applying national legislation. And so mixed international and national judicial panels were the norm, as were the investigative teams. And I found myself, in fact, running investigations with Kosovo investigators and often no internationals. And I think there was a real benefit in terms of increasing capacity and reinforcing independence and, in fact, enhancing the legitimacy of proceedings. However, I do think there were, for that particular model, there were drawbacks that partially explain why both UNMIC and thereafter EULEX did not manage necessarily to prosecute the most senior level of perpetrators that in fact they expected to do when the hybrid courts were started. And I think there was a key difficulty was in securing those suspected of war crimes committed against Kosovo Albanians, including those associated with the Serb military or police forces, basically who were no longer in Kosovo, a lack of jurisdiction to obtain them. Further than that, of course, trials in absentia were not allowed in war crimes cases. But on the other side, in terms of advantages, on the other side, in terms of the prosecution of KLA defendants, the difficulty there was witnesses and their families being very exposed to threats, intimidation, and worse. And in fact, a number of potential perpetrators and their supporters post-conflict went on to occupy positions in government and the intelligence services and the police services, and therefore cooperation with the UN, with UNMIC, and then ULEX in war crimes and organized crime and corruption prosecutions resulted in witnesses being heavily stigmatized and targeted as collaborators, thus very much discouraging cooperation with the international hybrid courts. And the result was, which was frequently seen, was witnesses not coming up to proof or recanting evidence at trial, which made these sort of factors made it very difficult to in fact reach high-level perpetrators. So in regard to the ULEX hybrid model, its executive operation certainly demonstrated to myself, as someone who's working within it, the critical importance of having probably a much more targeted focus and mandate to ensure accountability for war crimes cases, and also having a much more effective case prioritization, targeting the most senior level perpetrators. But then moving forward, following the publication of the Marty report in 2011 that I know many of you will be familiar with, that detailed grave crimes allegedly committed by former senior KLA commanders, and the preliminary investigation by the Special Investigative Task Force, the SITF, the Kosovo Assembly amended the Constitution and passed the law on the specialist chambers to allow for the creation of the court that is currently running, the KSC and the SPO. And I should say, as you know, the KSC, it's not a return to the system of hybrid mixed judicial panels. It has its own law, its own rules of procedure, and all of the staff are citizens of the EU or are drawn from contributing states, such as from the United States, where many of its prosecutors are in fact US citizens. And it has a very narrow and targeted focus and mandate. It has and continues to face a degree well, I should say this, I think one of its primary strengths is it has really concentrated on protecting witnesses and trying to learn from the mistakes of tribunals from the past. And so witnesses and witness protection has been really a massive step forward for it. And I in fact recall a number of witnesses saying during witness interviews, well, look, I was abandoned before by the internationals, so why should I believe that you'll protect me and my family now and in the future? And so I think that focus on witness protection has really emboldened victims desperate to finally tell their story and seek accountability without fear of repercussion. Equally, I think the prosecutor special, or the SPO, the prosecution part of the chambers, has investigated allegations in a much greater depth, opening new evidential leads that have led to very senior former commanders being indicted, which again was something that may have been lacking before. And again, from a personal experience, I recall interviewing a suspect who said, I knew this day would finally come. So accountability for atrocity crimes committed in 1998, 1999 for some victims is coming late, partially due to difficult political circumstances in the intervening period. And so one of the difficulties is with this sort of continuous change in tribunals is the consequent delay, the erosion of evidence, the fading of memories, the dying and the aging of witnesses. And as we know, justice delayed is justice denied. But I do say that it's certainly as a potential model for the future, and of course that's a matter that really does require a great deal of legal analysis to see whether there are parts of what has happened, certainly based in Kosovo, whether that would be useful going forward. And again, it really is simply now, I think, a matter of examining the workings of not just the Kosovo tribunals, the Kosovo models, but also all of them to see what permanent or pertinent lessons can be drawn from them to see how we can be very creative in going forward.
Thank you. Thank you very much indeed. Certainly, this is an arrangement that has to be watched closely by everyone concerned and by the professionals. Let me now recall one of the statements made today by President Zelensky, who said that no matter how important the international tribunals are, the bulk of the work will have to be done at the domestic level. That's why I think it's very fortunate that we have together with us a senior Croatian prosecutor who is also a member of the same atrocity crime advisory group, which is being coordinated by Ambassador Williamson, Ms. Davorka Cholak, who has the hands-on experience with the prosecution of war crimes in Croatia. So what are the ways how this experience can be transformed and used in Ukraine? Ms. Cholak, the floor is yours.
First of all, thanks very much to OPG's office for inviting me. It's really an honor. Secondly, just a quick note on who I am and why I'm bothering here you so late. I'm a Croatian war crime prosecutor dealing with war crimes for the last 17 years. Actually, my last courtroom appearance was in November. Then I took the leave of absence to join Atrocity Crime Advisory Group and try to help my Ukrainian colleagues. Namely, Croatia is the only EU member state that has in recent history, unfortunately, also confronted an aggression and war crimes on its own territory. And I will tell you just briefly what have we done to ensure punishment who those committed the crimes. As Clint already said, we are still doing it even 30 years after the war broke down. In Croatia, investigations and prosecutions also began in parallel with the events of war, which is really challenging. Namely, there is no system in the world that can handle such large number of cases, which is why we have taken many reforms and many changes in our system just to be able to do that. This was primarily the reorganization of the work of prosecutors' offices as we determined the specialization. So we determined specialized war crimes prosecutors' offices, which was followed by investigative bodies, primarily the police, and later on by the courts. During the work on these war crimes, there was an exceptional need for changes to the normative system, especially when it comes to vulnerable groups like children or like persons who have experienced sexual violence during the war, which is why we took the opportunity to develop a comprehensive system of victim and witness support and protection. In the meantime, Croatia received candidate status for EU. And during these pre-accession and accession negotiations, we were to fulfill many, many obligations from Chapter 23, which is judicially and fundamental rights. And the war crimes were set there as a special benchmark to be followed. I can tell you that working on these conditions began very early, even before serious work on some other chapters. And complying with Chapter 23 was essentially the resolutions of a whole series of complex issues, such as legal and organizational changes in transparency of judiciary, in the strengthening of its independence, resolving the backlog, education. So all of these reforms actually ended in the reform of a complete entire judicial system, and the special attention was paid to the criteria of impartiality and independence. When it comes to the war crimes, this included the importance of continuous investigation and prosecutions in order to end the impunity. Ultimately, it was to effectively deploy research potentials in order to investigate the most complex and the most sensitive cases. Therefore, it was necessary to eliminate any bias and to ensure the uniform application of the standards. Many instructions were adopted to direct the work of prosecutors. We established our own database of all war crimes in order to prioritize. We focused on command responsibility. We made a list of priorities on national, regional levels. We set deadlines for research and coordination. We made joint teams for prosecutors and police because coordination in gathering evidence is one of the central issues when it comes to the quality of work. So standards have been defined regarding the legal basis and methods of investigation. Direct obligations were put on prosecutors. So what can I say from our domestic experience is that planning work ahead is extremely important. So when we adopted our strategy, it was a big step forward for us. In this first phase, in which I believe Ukraine is now, the most important thing is gathering and securing the evidence. In the sense that every piece of evidence is important, and securing evidence is crucial since the prosecutions will certainly last for many years. So by joining Atrocity Crime Advisory Group, I wanted to share not only best practices and lessons learned, but also I will share all our mistakes that were made along the way, so maybe Ukrainian colleagues can avoid them. Thank you.
Thank you so much indeed for this, and it's really very important that you are now directly advising the Ukrainian colleagues with all this unparalleled experience, in fact. And let me turn now to our the panelist who is closest to me, but that's probably the reason why I'm giving the floor only now. But in fact, Mr. McBride is as I think most of you know, is a renowned expert in European human rights law and also a practitioner in European human rights law. And the question that I wanted to ask him is very much related to what has just been said by Ms. Cholak, but also what a bit earlier today the Director General Yakoumopoulos was saying, that in fact Ukraine is in a unique situation where it is a state party to the European Convention on Human Rights. Its compliance with the convention is scrutinized by the European Court of Human Rights, and Ukraine is facing this large-scale war right now. Ukraine has become the crime scene, as already I think Prosecutor Han mentioned today, and certainly, as also Mr. Yakoumopoulos was explaining, there's plenty of key standards that are developed by the European Court of Human Rights that are directly applicable now to Ukraine. So my question to Mr. McBride is, what are the most salient sort of points that need to be highlighted already at this stage and in this forum and at this late hour? Mr. McBride.
Thank you very much, Nicola. I hope this is working, yes. There are a lot of problems that can arise. The European Court has had an immense number of cases concerned with war crimes prosecutions, even though, of course, it's not a body dealing with prosecution, because the issues are raising questions about claims of violations. There are two streams. One is the question from the perspective of the victims, and the other is from the persons who've been convicted. And Christos already touched upon this point earlier about the question of speedy and effective investigations. And most of the complaints about this have actually failed because, in fact, they have been dealt with appropriately. But there are issues which have been seen where you have problems, particularly with cooperation with other countries, which have led to long delays. That has given rise to some difficulties. But another point the court has addressed is concern about the question of prioritization, even though that is an important question, because there have been cases where it's concerned that you've prioritized on dealing with the commanders and left the situation of those who are the individual victims. That's a difficult balance, and the court is not trying to criticize, but it's certainly an area where this, I think, is a major problem which needs to be kept in mind as things go forward. The main cases that have concerned, however, have been attempts by those who've been convicted to challenge their convictions on the basis of reliance on human rights. Happily, I think, in most of the cases, those have not been successful, but it is important to realize from those lessons that there are issues which can be disastrous if you have a situation. This comes back to the point Mark Ellis was raising about the acceptability of a conviction, because if you have doubts about the way in which the case has been handled, then that undermines the legitimacy of it. Some of the challenges have come from the point of view in relation to the prohibition on retrospective liability. This has been partly with the misuse of standards which have changed over time, because understanding of some of the requirements of international criminal law have evolved, and sometimes the standards are better now than they were, particularly in the 1950s when some of the issues have been raised. But you've also got the question of whether the national courts get it right, and that has also been an issue where some questions have been raised where they've misapplied, and Lithuania has had difficulties with this, although subsequently it managed to clear this up in guidance within the courts. So getting it right is important. At the same time, the court has been quite understanding about the fact that there are differences of view about what international criminal law means. And one important case against Germany was very clear that where you may have two different views which exist concurrently about what international criminal law requires in terms of elements of genocide, that doesn't negate the possibility that there is foreseeability for the person in that circumstance. And so in those circumstances, even though there were different views, since those views were generally well known, the person could not plead the idea that it wasn't foreseeable that he would be convicted. So that is an area. There's also a question about changing punishment, whether your criminal law has got the right level of punishment. Attempts have been done to change that, but if you do it retrospectively, from the time when the event took place, then you will have difficulties, and that has been a successful basis for challenging in some cases. Fairness has also been clearly an important thing. That's the lifeblood of the European Court is Article 6 of the Convention, and fairness issues arise. But indeed, in practice, the cases have not been particularly successful, but they show important points to worry about. There was one interesting case, for example, where the judge had been someone who had fought in the war, and I guess that's going to be true in the situation here. The European Court, however, did not accept that merely because the person had fought in the war, that this was a basis for saying that that was lacking in impartiality. But you need to be careful, because if the judge had said other things, then you may have problems in the future. You also have questions which have raised about the access of the evidence, and Judge Morrison was very important about the role of the prosecutor in providing exculpatory evidence. That is something which has come up from time to time as to whether or not that has been provided. It hasn't been demonstrated, but it is an issue which needs to be constantly kept in mind, that there should be the possibility of having exculpatory evidence. And that includes the ability of the defendant to bring that evidence. At the same time, as at least in one case I've seen, you have the situation where the defendant is trying to undermine the proceedings by calling numerous witnesses who will actually add nothing to the proceedings. And the European Court has underlined the important point that it is the court which determines the relevance of evidence, and therefore it decides whether or not there is a need for particular evidence to be brought forward. There are also problems. Fairness comes up in the question of length of proceedings. There are many cases where it's suggested the proceedings are too long. But the main test that the European Court applies is there any inactivity in the proceedings? Although it has sometimes been particularly sympathetic to the special difficulties which are faced with these kind of crimes, which make it much more difficult to process them in the way you would expect with normal criminal proceedings. We heard earlier about in absentia proceedings, and that is, of course, an issue which may be pertinent here. And one successful challenge came in relation to Croatia. Not so much from the question of the legitimacy of holding the proceedings in absentia, but the question of having a retrial after those proceedings. But that's less important in one sense, because it's the focus upon the real attempt made to ensure that a person who is being tried in absentia is aware of those proceedings and has that possibility either of attending or being represented in those proceedings. If there is not a genuine effort made to get hold of the person, then you're going to have those kind of difficulties. Two final points I would make. One is there have been various attempts to challenge the prosecution on the basis of discrimination, in that there was a situation where you have some cases being tried in one tribunal and some being tried in another. And the argument is that the other tribunal, from the one where the person was tried, was more lenient in terms of its sentencing. That argument has not worked, but I think it's very relevant to the situation where you may have both international tribunal and domestic one. The other point, I think, to bear in mind is the question of double jeopardy, which has been raised. And there are two elements to that. One is that the European Court has been faced with a situation where people have benefited at one point from an amnesty, but the view is that an amnesty is unjustified in relation to the kind of crimes we're talking about. And therefore, in those circumstances, even though a prosecution may have been ended and on the basis of the amnesty, that is not a barrier to bringing proceedings subsequently for the offence which the person is allegedly committed. But the other point about double jeopardy, which I think is worth mentioning, given that there may be attempts to bring proceedings even in Russia, where you may get light sentences imposed. The European Court's view on double jeopardy is that convictions in other jurisdictions are not a barrier to proceedings in another country. So in those circumstances, if you have one country which imposes lenient sentences for a situation, it would not be a barrier to bringing proceedings in another country for that purpose. So that's very much roughly where you are. But the important thing is, I think, to learn from this that although human rights must be respected, they are not a barrier to securing accountability. Thank you.
Thank you. Thank you very much, Jeremy, for this. Again, wonderful points, and I'm very grateful to the panelists for their brilliant presentations. Very short, very succinct, very clear. Each of them would deserve a separate panel, if not a separate conference, I would say. But I appreciate that this is a high-level conference, and we need just to jot, some of the most important issues. And I also, before the conference, I had a firm decision to open the floor for questions, and also I have plenty of questions to the panelists, but I assume the organizers will not appreciate that. So with this, thank you very much, and looking forward to the continuation. Thank you.
Thank you very much. Thank you very much. And now we have only one event left. Only one event. It's a presentation of the exposition of National Museum of the History of Ukraine in the Second World War. Please welcome Director of the Museum, Yuri Savchuk. Mr. Savchuk.